Evo for the next hour. Sit back and listen to expert interviews in the fields of legal, health, financial, and home improvement. Listen to such educational shows on community association law, air conditioning repairs, plumbing repairs, estate planning, property damage claims law, real estate law, wealth management, personal injury law, family law, assisted living, and men's health. Now, sit back and enjoy the next hour of Ask the Experts.
Hey, here we are, our second show this week, Thursday. We've changed now. We are on twice a week now from 6 to 7. So now you'll have us for your drive home. And this is the first Thursday of the month, so that means it's K. Bender Rimbaum. These are community association lawyers, not just lawyers. They are the best of the best. And, God, you guys have been with us for, feels like forever. One of the senior partners of K. Bender Rimbaum, we have Robert Kaye.
Hello, Steve.
Happy New Year.
Happy New Year to you and all our listeners.
Yeah, no kidding. And, God, I got to tell you, this morning we put things up on social media about the show today, and we must have gotten about 25 responses, and for the last 3 weeks we've probably gotten about 70 emails asking us what to ask Robert, and then we'll get a ton of phone calls today. We've already got 2 people waiting to get on, but this is an incredible show. If you live in a HOA or condo, or especially if you're a board member or management, you will love this show. You're welcome to call in. Phone number here is 888-565-1470. And the guy who tells about his firm the best, Robert Kaye.
Thank you, Steve.
Because we have a new audience now.
Hello, everybody.
And tell them about what your firm does.
K. Bender Rimbaum does community association law, as you indicated, meaning condominiums, homeowner associations, cooperatives primarily. 90+% of what we do is geared just to the day-to-day legal needs of our association clientele. We do that out of our Pompano Beach office, our Palm Beach Gardens office, and our office in Tampa. The types of matters that we are involved in are basically everything that associations face. So reviewing the covenants, providing advice to the board, opinions as to what they can or can't do under certain circumstances, dealing with issues of owner violations, dealing with unpaid assessments, dealing with contract negotiation, construction defect issues, complex litigation type issues. Across the board, everything they need. 24/7.
Yeah, listen, if you've never been a board member, you probably don't realize all that goes on. There's so much. It's like running a big corporation.
It is, and they usually have hundreds of thousands of dollars a year in their budget, some into the millions, and it's a big company. So it's important to have the proper guidance from experts, be it accounting, be it management, be it legal. These are important aspects in operating any association.
I'm going to throw this in. You might have been president of a large corporation, and now you're on the board. Don't try to do this yourself. Get people that do this every day for a living, and this is most of your practice.
Absolutely. I mean, even those, if you're an attorney who doesn't practice in the area of the law and you're on the board, you'll learn quickly that it's a lot different from most of what you're used to. So it's important to have the proper guidance from those who are qualified. And we have several of our attorneys are board certified by the Florida Bar, which is a recent new certification that was offered in 2017. I've been since 2017, and several of us joined. It was 2018, and then again in 2019 they added another group. So
that people know you do Dade, Broward, Palm Beach, Martin, and you're also in Tampa now too.
We are. We pretty much cover almost all of Florida.
You do. Listen, you can see our boards right now.
We have some callers.
Oh, we do. We have some callers. Let's go to Susan first.
Oh,
Hi, Susan first.
hi.
Hello, Susan.
How are you?
I'm doing well. How
Good.
about you?
You have a question for Robert?
I do. I have a couple questions about emotional support dogs.
We've been waiting for those, haven't we?
Yeah, right? Oh, my
that comes
gosh.
up every once in a while.
It does.
Yes, right? Crazy. Anyway, my first question is, can we actually, as an association, institute rules for emotional support dogs, like as of weight and what breeds or that kind of stuff, or they have to be carried off the property or they have to this and that?
You can have some rules that are addressing emotional support animals, but you cannot be as wide-ranging as what you've described. You cannot limit breed. You cannot limit most places that the dog can go. You cannot mandate the carrying aspect. Emotional support animals are not pets. They're treated under fair housing laws and are given special treatment well beyond what you consider logical and normal, but that is the state of the law. So if you're considering regulations on how emotional support animals are to be kept within your community, it's a good idea to make sure you have an attorney that is familiar with the area that can review them and advise you as to what you need to be doing or not doing within them. And I think that would keep you safe.
Oh, I got you. Okay. Yeah, because, it's definitely a sensitive subject. Right. I got you. Okay. And does that animal need to be, if it's an emotional support animal, does it need to be with that owner all the time? I mean,
No.
Can they just leave it? It does not. I didn't think so. Okay. And then can anyone see any of the documentation, because of course they have to submit certain documentation to have an emotional support dog. So is anyone privy to that information?
That would fall under the exception under the official records that are open to the inspection by other owners being medical related. Those types of records are not something that other owners would have access to.
They would not. Now, would all board members have access to it, or
board members could, yes.
Board members could have access. Okay, all access to
But
them.
you
but
could
not all
also,
owners.
the board could restrict access as well if it chooses within itself to just certain members of the board or officers or committee members. That's
Right.
a decision the board can make.
The board would have to make that decision. I got you. So in other words, we really can't the rules, it's kind of touchy of really putting institute. You can't put any kind of rule in there that it can't be a certain breed or a certain height or a certain weight or a certain, only have 3 legs or, whatever it is. You can't.
Unfortunately, the law is really weighted toward the disabled owner that needs the support. And, you are allowed to prohibit animals that are nuisances, that are vicious, that are causing real problems within the community, but just because a breed might be does not mean you can prohibit that. And if you have pet provisions in your documents with weight restrictions, that would not apply to an emotional support animal.
Right. We have just for your information, we have a no pet policy, actually. And now we've got pups popping all over.
Well, for many of our clients, we create a package of documents for use with emotional support animals on a flat fee basis where it contains the application form that if somebody is asking for permission to bring in an emotional support animal, for them to fill out what type of information is necessary to be provided by a qualified medical provider, and then some suggested rules that the board could consider for the use of the property by the individuals that have it that would keep you safe.
I gotcha. Oh, okay. So that's a package that because we do have some documentation that they have to, but then, you're up against it. They falsify that, and then, what can you do, right? I mean, how can you prove, how do you prove that someone, if it's false, but how can you prove that? You can't really
That is
denying one.
a difficult case to make, certainly, but
Yes.
not necessarily impossible, just can be expensive.
Yes, exactly. Right. You got that right. Right. Exactly. Because to fight that. And then we can't force someone to carry a dog off the property or anything like that.
Generally, no, but it depends on the circumstances that you're addressing. You can't do a blanket thing like that, but if there are certain areas that might qualify for either in a stroller or carry. I mean, it's hard to require someone to carry a 80-pound emotional support animal across the common elements. That might be problematic.
Right, I got you. Okay, yep. So that's exactly what I thought, but I thought I would ask you guys. Thank you so
sounds
much.
like you're on the right track.
Thanks, Susan.
Yeah. All right, thank you.
Okay, we have a line open at 888-565-1470. If you want to jump in, let's go to our next caller, Cameron.
Hi, guys. How are we all doing tonight?
Good, Cameron. How are you?
Good. Thanks for holding.
No problem at all. I just have a couple of quick questions for you. At our condo, we just have a couple of issues that we don't know how to deal with. We have one owner who is getting more elderly, and she lives out of state, and she would like, well, I should say, she let FP&L turn off her power. And she doesn't want FPL to turn her power back on unless she's there. And she might not even ever come back again. And we're wondering if the board, if there's any way that we can have the right to contact FP&L and get the power turned back on, because we're just afraid that something might happen in the condo, a mold situation, something like that might have an effect on the whole association.
Well, I think that rather than the association attempting to take that on, because in all likelihood FPL would not undertake turning on power to a unit the association isn't the owner of, is to adopt a rule within the condominium that requires owners to keep their power, their units powered at all times, and to maintain temperatures at a certain level so that mold isn't something that can possibly develop and spread throughout the building. The association has the obligation to operate and manage the common elements and to make sure that nothing is going on that might cause some kind of damage to it from within the units, and that would be a reasonable rule within the scope of the board's authority, assuming the documents give you the authority to make rules, which most condominium documents do. That would need to be confirmed, but that would seem to be the better approach. And then if the owner fails to comply, then the board would need to take further enforcement action to compel it, which would likely take it through arbitration with the Division of Condominiums, at least currently while the arbitration section still exists, to compel that. But ultimately, you should be able to prevail on that.
Okay, so it would end up then being a, again, as you said, incorporate rules, and then a
arbitration case, yes.
An arbitration case, which would then go to an arbitrator, and that would be his decision, and that would be the only way to really enforce that. Right,
and it's possible that you could take that to court if, say it's in a time of year when it's obviously hotter and wetter, and then it's more of an imminent concern. You can get out of arbitration and go to court for an injunction. That would speed things along.
Okay. All right. I understand the answer to that one. And just one other question we have is, in our development, we have an owner that passed away last year, and his estate is now delinquent on their dues. And we've tried to reach him, or we sent certified mail and that kind of stuff to his caregiver, and all the mail is just returned to us. And so we don't know what to do. We don't know who to contact. We don't know what our next step should be.
Now, you mentioned an estate. Is there a probate action that's actually pending in the court? Do you know?
Well, we don't really know. It's in New York, and he's
Well,
up
it
there,
would still have to be done something in Florida. If the property's in Florida, there would have to be some kind of proceeding in the state of Florida that addresses it.
So
the best method is to just proceed as normal when someone's delinquent with the lien and foreclosure process. And the attorney should be able to meet the statutory requirements and ultimately, if nobody replies, foreclose on the unit.
Okay, so I guess then our next step would be then to have to get an attorney involved in order to find out if there is a probate action on this property going on in Florida.
Yes, and that's not that difficult to do. The clerk of the court's website is generally available, and you can find out quickly whether or not something's going on there.
Okay, and because I guess after the person passes, then in New York, wherever it is, something has to happen up there, and all his property is thrown into them, and then they decide what's going on down here with the property that's out of state.
Well, I don't practice in New York, so I'm not sure what procedures they have up there, but chances are what you've described is very likely.
In New York, don't they just send Luca Brasi?
Just with the fishes.
Yes. Thank you, Cameron. We're going to go to break.
Right.
And, hey, we got Joey and John and Rich holding. We'll be right back.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with K. Bender Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, K. Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert Kaye, Michael Bender, and Jeffrey Rembaum, K. Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680.
And we are back. This is the Ask the Experts show. I'm Steve O. And we're here with one of the senior partners at K. Bender Rembaum, Robert Kaye. And before we go to our calls, you do the most incredible thing. I call it giving back to the communities. You do all kind of classes. So let's go over this month's classes.
Well, we do. First and foremost, we have our Ask the Attorney series.
My favorite.
We have two sessions this month. The first one is a week from today, January 9th, at the South County Civic Center in Delray Beach at 11 a.m. to 12:30. There will be a lunch served, sponsored by Community Cable Consultants. We thank them for that. So people up in Delray Beach should certainly consider coming to that. As we've discussed before, similar to this show, it's a town hall forum where the participants in the audience are asking their questions. There's no agenda. We don't have a set format that we're following. It's just basically an open discussion on the issues that the people that are in the audience want to talk about. And then our second one is also on a Thursday, January 23rd, at the Village Civic Center in Sunrise at 6800 Sunset Strip at 6:45 p.m. until 8:30 p.m. with refreshments, not a meal, but light snacks.
Okay, they're free.
So that's our second one for the month of January, and then we have more in February. If you go to our website at kbrlegal.com, you'll be able to see some of the upcoming events, including the Ask the Attorneys. And you can register to attend by contacting registerkbr.com and finding the event that you want to come to. On Wednesday, January 8th, in our Palm Beach Gardens office at 3 p.m., there's a condo board member certification course from 3 to 5:30. And then on Tuesday, January 14th, in Pompano at 6:30 p.m., Navigating Federal Fair Housing Act Assistance Animal or Pet. Coincidental to our earlier caller about emotional support animals. That one is usually a pretty popular event. And then on Wednesday, January 15th in Palm Beach Gardens is the Homeowner Association Board Certification course at 3 p.m. That's at 3 p.m. Wednesday, January 15th, board member HOA certification. Tuesday, January 21st in Pompano Beach, 6:30 to 8:30 p.m. is the HOA board member certification. So if you can't make it to Palm Beach Gardens on the 15th, you've got another shot on the 21st in Pompano Beach. And then on January 22nd, there's a doubleheader going on in Palm Beach Gardens at 3 p.m. The 2020 legal update, that's changes in the laws from 2019. Why they call it 2020 is because that's when we presented, but it's for changes in the laws from last year. That's from 3 o'clock to 5:30 p.m. And then at 6 o'clock, board member and officer liability insurance policies. You think you're covered? Think again. 6 o'clock in our Palm Beach Gardens office, 6 to 7:30 on January 22nd. Again, go to kbrlegal.com, and all of these will be identified on the website. You can send us an email at info@kbrlegal.com or call 800-974-0680.
You're going to be busy.
This is a busy month.
Wow.
So who's next on the phone?
Let's go to our phones. Let's go to Joey.
Hello, Joey. Joey still there?
Joey.
There he
I'm
is.
on the air, I hope.
Hello,
Can you hear
Joey.
me?
Hi, Joey.
How are you? Hi, how are you doing?
I
How are you?
recognize
Good to hear
that
you.
voice. Happy New Year.
Happy New Year to you, too. Yep, absolutely.
This is a great, this guy loves talk radio, and he's a really good
I'm
guy.
a talk radio guy for sure. I'm a fanatic. But, well, here, let me just give you real quick. It doesn't seem like there's much time left, but I've served on boards since 2011.
Oh, God bless you.
Yeah, I know. I'm a glutton for punishment, right? But and also in two different communities, and I've dealt with 4 different management companies with that time. However, I am now on the other side of the fence. I am a resident of a condo association, not on the board, and I have issues with the board. Now, you sound like you represent associations.
Typically, yes.
Typically, all right. But I have something that's pretty generic as far as law. We have some board members on this particular board that have been serving for 18 and 20 years. And apparently there's a new statute, I don't know if it's a state or a Florida condo statute.
State law, yes.
That now limits them to 8 years.
Yes. But that was adopted in 2018, and that's when the 8-year time clock began.
Well, that was part of my question. In other words, since the law was enacted last year or 2 years ago, so the people with the 20 years could stay on for another 6 years.
Yes.
Okay.
And then even beyond, under certain circumstances, if there isn't enough candidates that are willing to serve, they're allowed to stay on. Or if 2/3 of the owners vote to have them continue, then they can stay on.
Well, how is that possible? If they're not allowed to be on the ballot, how could 2/3 of
Now,
the
they're
voters-
allowed to be on the ballot, but they would be term limited out by virtue of having served continuously for too long. But that the statute is not written in a way that you can't be on the ballot. So, and
that's why I'm calling. It doesn't make sense.
Well, a lot of the laws don't make sense.
I have my 8 years in. I'm not allowed to be on the ballot, but yet I can be on the ballot. But I'm not allowed to be on the
you're
ballot.
definitely allowed to be on the ballot. The only way you're not allowed on the ballot is if you're delinquent in assessment or any monetary obligation to the association at the time of your notice of intent to run is up, or if you're a convicted felon whose rights haven't been restored for a 5-year period. So unless you're one of those classifications, you have to be included on the ballot so long as your notice of intent to run is timely delivered.
So it's basically a toothless law.
Not a toothless law because, but again, it hasn't kicked in yet. It won't kick in until 2026.
Right. Okay. All right.
So he
And honestly, by 2026, it might not be the law anymore.
Yeah, right. Yeah, that's a fact. Yeah, that's true. Well, thank you very much. I appreciate it.
Well,
so
thanks
much.
for listening and thanks for calling.
Take care, Joey. Good hearing you.
This can continue. Take care. Happy New Year again. Bye-bye
Same
now.
to you.
Let's go to John.
Hi, Mr. Kaye. I'd like your comment on thanks for taking my questions. I just have two. Can you comment on a 7-member board that limits meetings to 3 board members to avoid posting a board meeting open to all unit owners?
Well, if 3 board members are meeting, they're not having a board meeting, and they cannot take any official action. So it's just basically them spending time together and discussing things, which they're allowed to do, but they cannot take any formal action that way.
Is that?
It's legal, yes.
No, not legal. Is that the? I'm getting ethical here and moral. Is that?
Well, then you need a clergy.
That's a good question. Maybe an attorney. I mean, a clergyman who's a condo attorney.
Well,
I like your reference to The Godfather.
The intent of the legislation is that when the board is taking action, they should be doing so in an open format. But there are ways within the law that they can get around that, but it's not encouraged.
Right.
Now, for instance,
action that could mean a lot of things.
Yeah, well, the board can take action by a written resolution signed by 100% of the board members and never have a meeting. That's allowed under the law. It's not encouraged in condominiums, but it's not something that would invalidate any action that they take. Then it becomes political within the community. Do you want a board who's operating in the shadows, or do you want one that's open and communicative to the unit owners? That becomes more of a political issue than a legal one.
And not even a moral. Okay, that makes sense. Okay, my next question is, thank you, as far as access to condominium records, are email lists
email addresses are included if the association has adopted a policy of using emails for official communication and owners have consented to that use.
Oh, so they need to have do they need to have the policy in place, or can it just be a unit owner? Because we have a unit owner who's interested in the email list, trying to. It makes it a lot easier when you communicate with
of course it does.
Unit owners.
But
is that something that would be accessible to a unit owner?
Only under the circumstances in which it is part of the official communication method of the association, and only for those owners who have consented to be part of that.
Okay, so it's a little bit of a it's a process.
It's not a black and white slam dunk, but in all likelihood, if they're doing it, then you probably can.
Right. That makes sense. Okay. Thanks for your comments.
Oh, you're welcome. Thanks for listening.
Hey, we got to go to break. Rich, hold on there. When we come back, you're first up. Give everybody your phone number, Robert.
You can reach us at 800-974-0680, and that can get you through to any of our offices, Pompano, Palm Beach Gardens, or Tampa.
We're going to go to break. We'll be right back.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with K. Bender Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, K. Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert Kaye, Michael Bender, and Jeffrey Rembaum, K. Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680. You are listening to the Ask the Expert Show with host Steve-O. We will be right back with more experts in the field of legal, health, financial, and home improvement. Join us every Thursday from 5 to 6 p.m. Now, get ready for more Ask the Experts.
And we are back. This is the Ask the Expert Show. We are now on Mondays and Thursdays from 6 to 7. So we'll make your drive so much easier. This is the first Thursday of the month. So that means this is our community association show, K. Bender Rembaum. And I think we still got Rich is on the phone. Rich, are you still there?
Yeah, I'm here, and I have a question.
Go right ahead.
I had a discussion with a board member that one of the associations I manage. It's a 5-member board, and the board member feels that because it's a 5-member board, in order to pass or for the board to take action, they would need a majority of the board or 3 votes to pass anything. And I told them, I says, well, if you have a quorum of 3 at a particular meeting, then 2 would be the number that would officially pass any actions at the board at that meeting. What is your take on that?
Well, I agree with you, Rich, that if you have a 5-member board, then it takes at least 3 to be present in order to have a quorum so that a meeting can be held. And then it's a majority of those present that would decide on any issues. So 2 of the 3 can pass whatever resolution the board is considering at that meeting.
Okay. And I had another question. We had we did an insurance claim. We had an owner that we had a break in a sewer pipe that was inside his unit, went through a wall. And the owner did not have insurance, but we agreed there was a lot of damage. There was a lot of mold damage. Now, mold is not covered under the association policy, but we did offer to replace all the drywall that was damaged and had stains on it. And the owner is claiming, well, what about the mold issues? He had his own independent mold test done and said there were some dangerous readings. And our insurance just doesn't, the association insurance just doesn't cover mold.
No, it typically doesn't.
So to resolve this issue without a lawsuit.
Well, where is the mold? Do you know?
Well, what we did, we already went ahead. We got we did a claim, and we replaced all the damaged drywall, the whatever was wet and had mold on it, and it came from it was in a laundry room. It was basically laundry, bathroom, and a closet that were damaged. So we took care of the association obligation of the wall board.
Well, it sounds like there may be the possibility that some of the mold got into the area behind the wall between the units in the common element area there. And if that is the case, that could be the association's responsibility to remediate and eliminate, even without there being any insurance proceeds, as a common expense of the association to protect the common elements and other units from further spread.
Right. All right. Well, yeah, we in other words, the wall board that was damaged and it went through the bathroom and closet, that was all replaced. But well,
I think you need to get a little more information.
Another mold.
You need to get a little more information as to where the mold may be. If it's within the unit, then that's the unit owner's responsibility. Sorry?
Right. It's all within the unit.
So if none of it's behind the drywall, then that's going to be the unit owner's responsibility.
Right. Okay. We're just... Thank you for your advice, and we'll deal with it.
Very good.
Thanks,
Good
John.
luck.
Thank you.
Hey, we've got a few lines open here at 888-565-1470, especially if you're a board member or a management company and you have a question for Robert. Give us a call. Again, it's 888-565-1470. And you want to talk about your schedule again?
Well, sure. Now that we have a moment or two, we can be a little more leisurely about it. As we discussed a little earlier in the show, the firm provides education services to the public at no charge. And we have two different ways that we go about it. Maybe more than two, but two that we're going to talk about today. One is that we have seminars within our offices. In our Pompano Beach office and our Palm Beach Gardens office. There are several seminars scheduled in the month of January, and I'm going to talk about those in a second. And the other method is we have what we call our road show, which is the Ask the Attorney meetings out and about in various places around the Tri-County area. First one that we've got is coming up on next Thursday, January the 9th. And the Ask the Attorneys are without a specific agenda. It's a town hall format, and whatever we go over at these meetings are what the people in the audience want to talk about. It's open questions coming from the floor, discussions on the questions. Oftentimes, others within the audience will have similar situations or experiences that are along the same lines, and they interject, and we have discussions on that as well. It's not just a straight lecture.
If you come in with 2 or 3 questions, you're going to end up with 5 more.
Well, maybe. But Thursday, January the 9th, we have our first one in January at 11 a.m. at the South County Civic Center in Delray Beach at 16700 Jog Road. It's a good idea to register for all of these in advance, and you can do that by going to registerkbr.com or call the office at 800-974-0680. You can send an email to info@kbrlegal.com, and we'll get back to you. The second Ask the Attorney for the month of January will be on Thursday, January 23rd, at 6:45 p.m. In Sunrise at the Village Civic Center at 6800 Sunset Strip at 6:45 to 8:30. The one in Delray Beach next week will be serving lunch and is sponsored by Community Cable Consultants on that, and we thank them for that, and it's nice lunch. It's been 2 J's in the past. Maybe it will be again. And in the in-office seminars that are coming up, the first one is next Wednesday, January 8th at 3 p.m. in Palm Beach Gardens, which is at 9121 North Military Trail, Suite 200. It's the Condominium Board Member Certification course. Then on January the 14th in Pompano Beach, which is at 1200 Park Central Boulevard South, is Navigating Federal Fair Housing Act, Assistance Animal or Pet. So that's from 6:30 to 7:30, 1 hour discussion about the ins and outs of emotional support animal issues, and as well as other types of fair housing type concerns. It's always a very interesting one to go about. Then on Wednesday, January 15th, in Palm Beach Gardens at 3 o'clock to 5:30 is the homeowner board member certification course. And then on January the 21st in Pompano Beach at 6:30 p.m. to 8:30 p.m., we will again be having a homeowner board member certification course. And then on January the 22nd, we have 2 seminars going on in Palm Beach Gardens. At 3 o'clock in the afternoon is the 2020 legal update. And then at 6 o'clock p.m. is board member and officer liability insurance policies. You think you're covered? Think again. That's a good presentation on issues of insurance for board members, which is very important in operating associations. 6 o'clock to 7:30 p.m. That's what we've got for January. There's more to come in February, but we can talk about that next month.
Give the phone number again, too.
800-974-0680. Or you can go to kbrlegal.com and look for events. Or you can send
make
us an
reservations because they get filled up.
Space is limited. We have more space in the Ask the Attorneys. We can hold 100 or more in most of these venues that we're going to. Palm Beach Gardens a little tighter, so be sure to RSVP to that if you want to come. And Pompano Beach, certainly we can hold about 50, 55, so they do fill up.
They do.
It's a good idea to register.
Hey, let's go to Jack since he's been holding. Hi, Jack.
Before my question, I just want to say if anybody out there listening has never taken one of the courses from KBR, make sure you do it because it takes stuff that is typically not the most entertaining stuff in the world with regards to, entertainment factor, and they make it entertaining. I just wanted to throw that out there. Y'all do a great job.
That's nice. Thank you, Jack.
And the question is, you're welcome. When it comes to that dreaded kickback word, is a vendor allowed to sponsor a community association on-property event?
And give me an example of what you mean by
all right.
Why you think it might fall into the kickback range.
That's what I'm confused about. Let's say a community is having a pool party with a DJ and they're serving refreshments for a holiday, for 4th of July. And they seek out sponsorships to help cover the cost of the event. Is that okay? Like, since the monies are going to the event and everybody in the community is invited, is that legit? Is that okay to do? Are they going to get in trouble?
In my experience, yes, that is okay. As long as there's nobody getting any personal benefit from it, it's just a check that goes to cover the costs involved in providing whatever recreational event is going on. That's never been an issue.
Okay. Just wanted to be sure. And the other question, I did have another question. I lied. Confused a little bit about the association website issue as it relates to what must be functional for the visually impaired. Is it only if you're selling property on the website? Is that how is it? What, can you clarify that?
That's something that's relatively recently been a thing. Within the state of Florida, there's some companies that make their living by testing various entities and for fair housing type issues, then sending a demand letter and a lawsuit potential and basically extorting money from associations for unintentional violations. And the one that most recently has been received throughout the state involves websites that are out there because the statute requires associations with more than 150 units to have them that aren't accessible by visually impaired individuals. And You are correct in what you say that really applies in the sale of real property. At least that's the opinion that's out there. There hasn't been any test case yet because it's so new. But some have been settling. It's my understanding that the technology to make the websites compliant on this issue is relatively inexpensive and not that complicated to put into place.
Correct,
So
yeah.
it is something that associations should look into just to avoid getting sucked into this type of a situation.
Okay, it's good to know. Thanks for clarifying.
Sure.
Good job, as usual. Great show.
Hey, thanks for listening.
Good call,
Thanks for
Jeff.
calling.
Call back.
Good night.
Wow. We've had some good calls today.
They're always good.
Let's go to. We got to go to break.
Quick break, and
Yeah.
then
We'll
maybe
come
get
back.
one or
Maybe
two
we'll
more.
get some of these texts and emails we got.
Maybe.
We'll be right back.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with K. Bender Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, K. Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert Kaye, Michael Bender, and Jeffrey Rembaum, K. Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680.
Attention.
So we're back here. This is the last 9 minutes of Ask the Experts. Today's first Thursday of the month, so that means it's K. Bender Rimbaum. We're here with Robert Kaye answering your questions. Condo Association, HOA. We've had some really good questions today. If you want to get a quick phone call in, we might be able to get one more in. 888-565-1470. We get so much mail now for this show, and I was just asking Robert, because we got so many people asking the same question about a real estate agent. If they're a board member, are they allowed to sell units? Is it a conflict?
It's potentially a conflict, but not necessarily. It really depends on how the board member goes about it and what they're doing. What is a problem is if a board member uses information that only the board member has privy to because he's on the board, or as a board member somehow refers business to himself that should be more generally available, that could be a potential problem. Board members are not supposed to earn money off the association, but a real estate agent is in the business of assisting people in the purchase of real estate and make commissions for doing so. And the fact that they're a board member doesn't make it a conflict because they're doing it within the same community. As long as they're keeping it separate, making full disclosure of what they're doing to the rest of the board, that generally would be okay. But you got to be careful. And if you can avoid doing it, it's always preferred. But if there's ever a question, you should certainly run it by the association council for the specific facts of the situation to determine whether or not there's a real issue.
That was from Bob in Palm Beach. This is from Shelley, Boca Raton. Our association doesn't want corporate ownership. Can they do that?
Doesn't want corporate ownership? They can do that. That takes an amendment to the governing documents to limit the use of the property to only natural person ownership. Now, saying corporate ownership is old school because today there's other types of business entities that are actually more in vogue than corporations. An LLC is not a corporation. And if your documents limit corporate ownership, an LLC isn't in violation of that.
That's right.
So you have to be careful of how your documents are written in that respect. And for those who are within communities that are thinking of that or have that already, check your documents and see you may need to be updating and amending them to provide for more involved situations.
Here's Lewis in Weston. Can a condo association enter into a contract for cable, TV, and bundle in internet services at regular price and make the owners pay directly to the service provider for the internet service?
So just providing part of the service,
Yeah.
and let them deal directly. The law does not mandate one or the other. So if the board chooses to go that route, the law does allow associations to basically bulk the cable and internet services, bulk purchase them through the association as a common expense, and owners would pay them through the association, but they can cherry pick. They can take just the TV and let the owners deal with the internet themselves. They can also buy a basic package, and then the owners would have to, if they want to upgrade, they typically would pay directly to the vendor.
Do some condos and HOAs actually take on the package and charge the owners?
Oh, absolutely. There are a large number of them do that. And in fact, our sponsor at the Ask the Attorney next week, Community Cable Consultants, helps associations in negotiating these very things.
Actually, they were there when I was at Ask the Attorney.
No, you remember.
Yes. Becky and Boynton, is water a common expense for condos? Shouldn't each unit pay for their own individual use? And she went in more detail. She didn't like the fact that some people use more water than others
That's
do.
going to happen, yes. Well, it depends on your documents and the construction of your building. A lot of the older condominiums down here were done with a single water meter, and that made water a common expense, and it didn't matter if somebody left their shower running for 2 days, everybody has to pay for it. We've had association clients through the years adjust their situation by upgrading and putting in individual meters off of the main meter. It takes some amending of the documents and some capital improvement expenditures that also may require a vote of the owners, but it can be done. But again, it's going to be a case-by-case situation depending on what is going on in the actual community.
Sounds like a huge expense, too.
It could be, depending on the size of the place.
Craig in Cooper City, how often should the board of directors have the association's governing documents reviewed by an attorney for potential updates and amendments that may be needed?
Well, it's a good idea to do it on a regular, periodic basis. There is no exact right answer on that, so long as it's being done. If they look at it 5 years, 7 years, that's a good idea to do. But if it's going longer than that, I think then you're starting to fall into a situation where you probably need to have it done.
Okay.
So 5 to 7 years is, I think, a reasonable amount of time, because they're changing the laws all the time, and that's important.
We've got about another minute. I'm going to ask my favorite question. I'm on the board. Why should I hire your firm?
Well, our firm is one that is made up of a large percentage of board-certified attorneys that are experts, as it were, in the field of community association law. So we have a vast amount of experience in the area, and we are able to assist. And besides that, our own particular philosophies involve as a customer service thing. We have live receptionists on the phone. We don't go through voicemail loops. We have policies of getting back to our clients in a prompt and efficient manner in an understandable way. So we don't have enough time because we're being played off. Go to the website at kbrlegal.com. We do have Ask the Attorneys on January 9th and 23rd. We have upcoming events in both Pompano Beach and Palm Beach Gardens that I talked about, but there are many this month, so check it out.
I love doing your show. This is a great
and I
show.
love doing it with you.
And apparently people love it too. We will be back on Monday. I won't. I'm having surgery Monday, but we'll be back on Monday from 6 to 7 with Ask the Experts. Have a good weekend.
Thank you, everybody.
Thanks for listening to the Ask the Expert Show, featuring interviews with local experts in the fields of legal, health, financial, and home improvement. Call our office at 888-574-6999 to become one of our experts on the show. And tune in again next week for more Ask the Experts with Steve-O. The opinions expressed on the preceding sponsored program were strictly those of its host, guests,